alikulinda.
One time.
Squeezed, eh? We argue that the Jackson does not expose your face.
Angalia. Kuna bado. Hapa. Pita. Kuna bado hapa. Hiyo side nyingine. Ameshakuja. Ndio amekuja. Haya. Akokoti.
What's interesting? Good morning. It's chilly morning. We appear not for the accused because we want to strongly oppose an attempt to charge Honorable Jayne. We oppose any attempt to take a plea because we are seeing the charge. For the quorum purposes, Your Honor, my name is Kalonzo Musyoka. We have with us Honorable Justin Muturi. It's a household name. Council here in Kihara. We have Council Keragu Watuta. We have Council Ndego Njiro.
I am present, Your Honor. Good morning.
We have Council Waireki Kiarie.
Good morning, Your Honor.
We have Council Malemba Daniel.
Present, Your Honor.
We have Council Nyamu Boniface.
Present, Your Honor.
We have Council.
Yes. Some of your advocates are not properly dressed here. So you can mention them for purposes of record, but
They will,
not address them.
I think it's the urgency of this matter, Your Honor, but we will comply.
Okay, thank you.
We have Council Wambugu Wanjohi.
Present.
And we have Council Mageto Miller.
Present, Your Honor. Again.
Oh, you seem to have met before.
Yes, I see that together.
Indeed. We have Council Ngera Alex.
Present, Your Honor.
That is the team on our side, Your Honor.
All right, thank you.
Good morning. For the state, my name is Ron. Together with Mr. J.V. Witi,
Good morning, Your Honor, once again.
Good morning, please.
Mr. Willie Momani, and Ms. Sonia. Matter is coming up for free taking. We are ready.
Your Honor, we have just seen copy of the alleged charge sheet. And Honorable Jayne Kihara is supposed to take a plea. The charge of offensive conduct conducive to breach of the peace. Of the Penal Code, Chapter 63, Laws of Kenya. With a casual glance, Your Honor, men and women, members of Parliament like Honorable Jayne Kihara, Your Honor, if it is that they were to be arraigned in court, some have said worse things. Some have even on record as saying they were going to transport goons to make sure that Saba did not happen. And they've never been arraigned. We have, for example, Honorable Kamket, a member for Baringo East, declared openly.
Sorry, Your Honor. It's very unfortunate that I have to rise when Senior Counsel is speaking, but we have an objection to make. Senior Counsel, if you allow.
This is just opening remarks, because we were just trying to point out selective persecution of political leaders. This is nothing, nothing, Your Honor, nothing short of political persecution which this country cannot
You
accept.
know, we have a concern with
So,
that.
Senior Counsel, I think you made your point. Maybe.
Yes, we were just going to ask, not even in the nature of the opening speech, but it is based on a lot of factual allegations that Senior Counsel, being from the bar, cannot present court without an affidavit. So we would plead that we go straight to the issue without the conundrum of factual matrix, which we are not able to respond to without an affidavit, so that we are on a very disadvantaged position.
Thank you.
Thank you.
Counsel, I hear you. Your Honor, I hear him. I take that objection. But even as I do, others are even on record as saying publicly, public notice. I think court should take judicial notice of that. Even prepared to steal the next elections. And they have not been brought here. We live in the same country, equal rights. We do not have citizen A and citizen B categories. And therefore, I invite my colleagues to argue against this plea taking and to ask the Honor, the Honorable Jayne Kihara, be released unconditionally to go and serve the people of our constituency, Naivasha. We are happy that you found the time because we are afraid, this being a Friday, the intention of our colleagues on this side was to detain her until Monday. But thank you for finding the time. We think that this is not the way to run a country, Your Honor. I thank you.
But Speaker, so you know court sits on Fridays, yeah? So your apprehension, in as much as you should not worry, we sit on Fridays, yeah? Oh.
Thank you. Just once again, my name is Kihara. And if it pleases you, I'll address you very, very quickly on the basis of why we are asking for a fund for the taking of the plea. Both ourselves and our clients have just seen this charge sheet, which is before the court. You have seen the quotation yourself, and the charge is based on section 94(1) of the Penal Code. What is called an offensive conduct that is conducive to a breach of the peace. Your Honor, when you look at the ingredients of the offense of that is charged with 94 Article 1, the particulars provided don't disclose any of the ingredients even on the face of it, assuming you have witnesses and assuming that we'll be able to do what we call legal surgery, where you have to look at somebody's statement, because I think we are operating for a basis that our client is entitled to exercise her right under Article 33 of the Constitution, the freedom of expression. She's an additional member of Parliament whose right and freedom to expression include much more than her personal rights. She has constituents to present and to speak on their behalf freely without any limitation, as to make representation on their behalf at both the National Parliament and any public fora, where her duty calls. I've looked, when you look at the ingredients, again, there is nothing insulting on the face of this. There is nothing abusive. And tremendous respect to the office of the Rana DPP. This is the kind of offense that used to be charged, that usually is used to charge a drunken man. the drunken man in the market center. So that we are talking. This is the kind of charge. This is not the kind of charge to bring a member of an elected member of Parliament who is serving her that term in Parliament to court. Thank you, and it's completely on the face of it unconstitutional. But my learned friend, Mr. Jiro, will be off further deeper.
Thank you, Your Honor. I'll also briefly address you on the legal basis of our application, then I'll invite my learned friends to further betray the arguments.
So, Mr. Jayne,
Yes.
before we proceed, maybe just for order, how many do you, because I can see you are battery,
Yes, Your Honor.
do you possess? How many of you would be
Thank you, Your Honor. Authority, I'm sure, would want to make,
after Jiro?
and so after Njiro, two others.
Yeah, I don't think we have any power to decide for them. Maybe the court could just indicate how much time all the three have for order. Instead of telling them how many could speak, we could agree on how. The three is okay, yes.
So let us hear, let them exhaust whatever they have.
Just stick to the point, Your Honor. I'm sure we are going to do this is proposing this.
You know, I begin to address you by invoking your jurisdiction. And I do so because we'll be of the Magistrates Court Act. But let me begin by section 3. It lays down the guiding principle. In exercise of its judicial authority, a magistrate was specified under Article 10 and Article 159, clause 2, and Article 232 of the Constitution. That's where you draw your jurisdiction from. And then as you exercise this jurisdiction, when adjudicating of our dispute such as this one, what is the court looking at? And section 4 says the objective of this, it says, Your Honor, that subject to Article 165, clause, it is so square borders between a denial, a violation or infringement of a right, a threat to a right, or fundamental freedoms. We address you on the basis that the section under which this charge sheet has been premised, that is section 94, subsection 1, was enacted in 1930, with the commencement date being the 1st of August 1930. It follows therefore, Your Honor, that with the enactment of the new constitution, the ODPP who has brought us here this morning ought to have been alive to the provision of section 7 to the 6th schedule to the Constitution. Section 7 to the 6th schedule, Your Honor, to the Constitution provides that all laws that were in effect before the effective date shall be read with the necessary modification, adaptation, alteration or alterations, so as to bring it into conformity with the provision of the Constitution. And while I am not inviting you to look at the constitutionality of that section, I am inviting you to look at whether or not the application of that section falls within the provision of section 8 of the Magistrates Court Act. I want to make it clear so that my learned friends on the other side may understand that I'm not invoking your jurisdiction to determine the constitutionality. I'm invoking your jurisdiction to determine the applicability of that provision. Therefore, in that sense, Your Honor, section 94, subsection 1 must be brought within the armpits of Section 7 to the 6th schedule. And the reason why the drafters of the Constitution made a proviso to save the existing laws before the effective date was to make sure that, Your Honor, that granted the circumstances that Parliament is not able to address all laws supposed to bring it to conformity, that the application of such a section may not result into violation of a provision under the Constitution. That is the reason why we have the existing, the clause saving the existing laws before the effective dates, and hence the enactment of Section 7. Having said that, Your Honor, Section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection, clause 1, provides that Article 10 bites all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating in a policy. In this case, Your Honor, you are implementing the law. And therefore you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is the value of human rights. That human rights binds you. And that is why Section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 bites you holistically without any possibility of waiver, and then you are told that you cannot determine a threat, you cannot determine a denial, you cannot determine a violation. Having said that, Your Honor, Article 10 also invites you to look at the rule of law. And also the question of social justice. And the principle of equality and equity. That is therefore to say, Your Honor, and I want to associate myself with the submissions made by senior counsel, is there equality, equal application of the law, granted the circumstances and the submission that he has made, because I consider them to be legal arguments. Number 2, Your Honor, the application of Article 10 invites you to look at the question of discrimination under Article 27. Because Article 27 falls within Article 10, where you are mandated or commanded by the Constitution to observe human rights. And therefore to say that, Your Honor, when you retire to make our application to the objection of taking plea, this plea does not conform to the dictates of the new Constitution. That is one ground of the objection. That it is not possible for you to ask Honorable Jayne Kihara to make a plea that will be unconstitutional for failure to conform to the dictates of Section 7. That's one limb of our argument. The other limb of our argument is that the same does not disclose an offense. Those are two grounds. That if she was to make, or she was to plead to this offense, one, she does not even understand what offense is actually facing her. Because even if we were to make an assumption for purpose of argument that Section 94 subsection 1, that it was in conformity with the Constitution, is it just the proviso that the Jayne Kihara, Honorable, offensive conduct offensive conduct conducive to breach of peace? This proviso of the law must be backed by particulars that speaks to that offense. We therefore submit that the particulars pleaded herein do not speak to the purported or to the alleged offense. These particulars falls within the provisions of Article 33 of the Constitution, the freedom of expression. To admit this charge, therefore, Your Honor, this court would be rising up to the occasion of limiting her rights. And the limitation of this right, Your Honor, under Article 24, the court has created a test that it must be justifiable for you to limit. It must be justifiable in a free, open, democratic, and civilized society. If that then would be the test and granted her status of members of parliament, would the taking of this plea not amount to the limitation of that particular right? And would that right be a justifiable one in a democratic society? A free society such as this one? A civilized society such as this one? That was not the intention of the legislation. That was not the intention of the enactment of the 2010 Constitution. And then even if she were to plead, Your Honor, even if she was to plead, that she made these remarks, Your Honor, would this conform to the provision of Article 50, Clause 2, Paragraph 4? And that's the doctrine I love speaking about, the doctrine of nurum crimen sine lege, that you shall not be charged of an offense if the offense itself was not known in law. And the argument that the offense is not in law is due to the fact of the jurisprudence that has emerged following the enactment of the new constitution vis-a-vis Section 7 of the 6th schedule. That had it been to be brought to the conformity to that provision, this offense would not be existing in our books of law. If we had a proactive parliament, and not a parliament like the one that we currently have, this perhaps would have ceased being good law in our books. But granted the circumstances that Parliament itself has not amended this provision, that Parliament is too lazy to bring it in conformity with the provisions of Section 7, are we left helpless? Is it therefore that the DPP has the liberty to charge any other person just because Parliament has become negligent? Parliament has refused to legislate? You are called upon by Section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, I may invite my learned friend, Mr. Kihara. Article 10 places you in the same pedestal with the Parliament. Because this court and Parliament is bound by that provision. So where there is ineptness and negligence on the part of Parliament, the court of law can rise up. In any case, the application of Section 7 vis-a-vis Section 8 of Section 7 to the 6th schedule, vis-a-vis Section 8 of the Magistrates Court Act, can only be applied by this court, not Parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interests. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, this is a court of law. If anyone feels injured by these particular statements, the recourse is not before you. The recourse is not to criminalize utterances that are constitutionally protected. When you retire, you look at Article 19, 20, 21, and 27 of the Constitution. I invite my line friends.
Sorry, especially those provisions, the last those articles.
Yes, Article 10, Article 19, Article 20, 21, and 27. And finally, Article 33. But also, look at Section 89 of the CPC, when a court can decline to admit a charge. Allow me just to read it as I invite Mr. Kihara. That is Article 90, sorry, Section 98, 89, sorry, subsection 4. The magistrate, upon receiving a complaint or where an accused person who has been arrested without a warrant is brought before him, shall, subject to the provisions of subsection 5, draw up or cause to be drawn up, and shall sign a formal charge containing a statement of the offense, with which the accused is charged unless the charge is signed and presented by the police or the ODPP. That has been done. When it is brought before Your Honor, then you are supposed to invoke subsection 5, where the magistrate is of the opinion that a complaint or a formal charge made or presented under this section does not disclose an offense. The magistrate shall make an order refusing to admit the complaint or formal charge, and shall record these reasons for the order. I invite Mr. Kihara.
And Your Honor, that is a perfect starting point for me. And I'll be giving you reasons why we should not admit this charge. You know, this charge is drawn, and it is alleged that the person before you has done something contrary to Section 84, subsection 1 of the Penal Code. And Your Honor, that is the section which I've opened. That section, and if I may just read the words that are in the charge sheet, that Jayne Wajiro Kihara, on 8th day of July 2025, at Nairobi City within Nairobi County, being in a public gathering, uttered the words to it. Now the words are there, the paragraph is there. It concludes, with intent to provoke breach of peace. So, I submit that that charge, as drafted, does not disclose any offense under Section 94, subsection 1 of the Penal Code. These are the reasons you know. That section reads, a person who in a public place or a public gathering uses threatening, that one, abusing, that's the second one, or insulting words or behavior. So, the operative words here are, those words must either be threatening, there is no suggestion that she used any threatening words, abusive, it is not alleged she used abusive words, or insulting words or behavior, it is not suggested that she used any insulting words. And then that is when an offense is constituted. So the charge that is before you does not have threatening, abusive, or insulting words or even behavior that would go on and cause breach of peace and all that. So basically, the offense that is before you is horrible. The other part of the section is just saying how minor that offense is. It's just a fine of 5,000 shillings.
Can you address the other element?
Yes, I'm coming to that. I just caught my eye in the fine, which is 5,000 shillings. So, then, with threatening, abusive, or insulting words or behavior, there's no suggestion that has taken place with the intent, one, to provoke breach of peace. That is the one that has been taken here. So that for you to have an offense where the intent is to provoke breach of peace, those words or that conduct must fall within the three parameters or any of the three parameters that I mentioned. What is before you does not fall under any. Under subsection 2, the Act then defines what is a public gathering. And what you will find is that one situation where there is a gathering is when there is any meeting. So basically, when a charge reads a public gathering, a prosecutor must take the charge to what kind of a gathering. Is it a meeting? Under paragraph A. Gathering or concourse of 10 or more persons in any public space. So you're not being told, were they 2 people? Were they 1? Were they 3? Because the minimum number is 10 or more. And it must also be in a public place. This charge does not say the public place or any place. We are just being told in Nairobi. All of us in Nairobi. Yeah, even here is in Nairobi. So, which is a public place. So, that way, the offense is not disclosed. Paragraph B. Any meeting or gathering which the public or any section of the public of more than 50 persons are permitted to attend or do attend, whether on payment or otherwise. There is no suggestion, it's not been indicated whether there were 50 people, whether these people paid to be there, they didn't pay to be there. So what is Honorable Jayne Kihara supposed to defend? These particulars are not in the charge. And finally, the other situation is the paragraph C. Any procession in, to, or from a public place. Any procession moving in or out of a public place. We are not told that these words were uttered in the investigations. When a charge is brought before you, under section 94, under section 134 of the CPC, one thing that should stand out is the following: that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving a reasonable information as to the nature of the offense charged. The information that is contained in this charge, Your Honor, is insufficient under subsection 1. It is insufficient under subsection 2 of section 94 of the Penal Code. absolutely right thing. Before I shift to that point. You know, when a charge, and the section which was just referred to, that is section 134, is indeed the section that implements the provisions of Article 50, sub-Article 2, paragraph B of the Constitution, that provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. The charge that is before you does not have sufficient details as defined in the implementing statute. So if she goes ahead and pleads to the judge as brought before you, it will be a violation of Article 50. So Article 2, paragraph. And important to mention, Your Honor, that under Article 25 of the Constitution, and for emphasis, I want to read what it says, that despite any other provision in this Constitution, the following rights and freedoms shall not be limited. These are rights which cannot be limited. And one of such is the right to fair trial. That is paragraph C of Article 25. The right to fair trial is the one that I had talked about in Article 50. So you are then placed in a position where you have a charge that is in contravention of Article 50, and you're being asked to allow a person to plead to those charges. Your Honor, decline that invitation. And Your Honor, I do not want to talk much because before we came here, we were before you again in another matter with the same prosecution team and Mr. Mageto for Honorable Bongori. And yesterday we slept very late because we were at the DCA headquarters to deal with an issue of Honorable Mukunji. And now we went to, the other day, then yesterday we were dealing with Jayne. And no. So that Your Honor, I do not want to tire you because we're also very stretched. But the context of that is that there's a pattern, and this court should rise to the occasion and see what is happening and uphold the Constitution. And that will be. And I invite my friend, our chairman, Mr. Mbogo Wajoi, to make something.
No, that is not the introduction they give to our chairman. This is our chairman of Gema Wado, which is an organization of about 6,000 lawyers. So you cannot just give an introduction to this.
Thank you. Well, it's another thing to do. Let us take.
We have an association which has about 8,000 lawyers practicing in Kenya, others in Kenya. It's called Gema Wado Association. Very many lawyers.
What he's not telling you is that he has now incorporated our cousins from Mount Kenya South.
Guys, our able chairman.
Thank you. Thanks for that introduction. Again, my name is Wambo Wanjohi, and allow me to concur with what my senior, Mr. Kihara, said, and what the state is doing. The state is using fire extinguishers to blow out a candle. Section 94 was meant for brawls in bars and fist fights in funerals. That is the purpose of Section 94, the Penal Code. But, Your Honor, let me go into why these charges before you are defective. Number one, Your Honor, there is no clear offensive conduct that has been identified. Section 84 says the charge itself is offensive conduct conducive to breach of peace, contrary to Section 94 of the Penal Code. The charge does not specify what part of the charge was actually offensive. And a simple reading of these particulars, I will just cherry pick some. I would say I want to talk about Naivasha because I know the goons were transported in NYS bus. How is that offensive? I want to tell the president, this is not about the young people who you went around promising heaven and what you are digging deep so that they go under. It will not happen. How is that offensive? Number two, if the president has been mentioned in this particular charge sheet, he is not among the witnesses. You see the complainants? Second, Your Honor, the use of vague words like offensive conduct without defining how and why it was offensive makes the charge overly broad and ambiguous. Second, Your Honor, no particulars of breach or threat to peace has been disclosed. The charge alleges intent to provoke breach of peace, but fails to state the following things. What disturbance followed, if any? Who was provoked? What specific act of violence or disorder was caused or threatened? There is no breach of peace in these particulars that accompany this charge. Third, Your Honor, we submit that speech alone is not automatically conduct. Section 94 is meant to criminalize conduct. It is clear. Offensive conduct conducive to breaches of peace. It does not criminalize opinions and political expressions. If the charge is based solely on speech, then the prosecution must show that the speech had a clear and present danger of causing peace. This threshold, Your Honor, has not been met. Fourth, Your Honor, we submit that no menswear is alleged, save for with intent to provoke breach of peace. To which we say, the charge does not state intent or even suggest that Jayne knew her words would provoke unrest. What she was doing was expressing her political opinions. guaranteed under Article 33. Now, Your Honor, fifth, we want to go to the issues of Article 50, 2B, and KE of the Constitution, whereby the accused has a right to be informed of the charge in sufficient detail, presumed innocent, and not to be convicted for conduct that is not clearly defined as an offense in law. Your Honor, this charge is too vague and imprecise to meet these standards. Sixth, Your Honor, there is no link between the words and the alleged offense. Even if this speech was quoted in full, it shows no incitement to violence. Actually, she's even giving her condolences. As I condole with the bereaved, quote, and I also empathize with those whose properties were destroyed. So this speech does not show any incitement to violence or encouragement of disorderly conduct. Condolences, criticism of police, political frustration, how is that a criminal act, Your Honor? And if that was the case, I believe half of Parliament would be in committee. Seventh, Your Honor, as I conclude, this this is a gross misapplication of the Penal Code. As I indicated, this provision is for brawls in bars and fistfights in funerals, and should not be used as a tool to criminalize free speech, however loud or uncomfortable it is. Finally, Your Honor, submit that even if all these alleged facts were true, they will still not amount to breach of peace under Section 94. Which makes the charge fatally flawed and ripe for striking out at the earliest instance. This will submit.
Your Honor, I'll cede the floor for 1 minute to Councillor Eregi, and then
Your last one.
yeah, last one. Then I probably just wrap it up in a minute.
You know, the agreement was that it was 2. I know this is mathematics, and I know lawyers. It was 2 after council, and that is the third. So but we have no objection.
Thank you.
Just mathematics.
Thank you.
Mr. Wayne,
Yes, sir.
so for 1 minute here.
Yes, for 1 minute. I wish to address you on an issue that has not been addressed by my colleagues at Senior, as to what should happen in the intervening period when you retire to render decision on the validity of the charge before you. Your Honor, the charge, as rightly put, is one under Section 94(1), a misdemeanor. And in light of the provisions of Article number 49(2), a violation is ensuing at the moment, in that our client is in custody. Article 49(2), the rights of an arrested person, provide that a person shall not be remanded in custody for an offense, the offense is punishable by a fine only, or by imprisonment for not more than 6 months. The one before court is one that qualifies under 49(2). As such, in the intervening period, it will ask for release of the arrested honorable man on her personal cognizance.
Your Honor, Honorable Jayne was apprehended in Naivasha in my constituency. And was escorted by a convoy of 30 officers, approximately, because she briefed us. 2 Land Cruisers, Your Honor, and the famous Subarus. Only to be presented before you this morning, be charged with a misdemeanor. I believe it's on Saturday? Yesterday, Your Honor, lunch hour. When I spoke to her, she was at DCI headquarters last night. As senior counsel, I thought, from what she told me, we did not have to use public resources to come in this morning for a misdemeanor. So I tried to talk to the deputy DCI, who told me I was going to look into that matter. And if they had properly applied their mind, she should not be before you, Your Honor. That's our submission. Finally, Your Honor, I want to refer you to the provision of Article 2 of our Constitution, which of course declares that this Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. Sub-Article 4, Your Honor, of section of Article 2, any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency. And any act or omission in contravention of this Constitution is invalid. Your Honor, my submission is that alleged breach of Article Section 94(1) of the Penal Code is unconstitutional. Because in violation of the very Constitution itself, and Your Honor, as Kenyans we should be very proud that we imported under Article 20, 19 and 20 of the Constitution, the Bill of Rights. Therefore, it behooves all of us, Your Honor, our courts of justice taking leadership to ensure strict adherence with Constitution 2010 and its valuable provisions, which actually is a constitution that gives freedom of expression. We've been addressed on that. Therefore, our plea, in conclusion, Your Honor, is that this harassment through you should stop. I found you recently, I do not know whether it was before you, when we had the privilege to appear together with Chief Justice Emeritus in the case of Rosenjeri.
No, it was a different one.
You look like...
He's not my brother.
Yeah, you look like... Your Honor, Musyoka is a very good case to be found at this time. When the magistrate, your brother magistrate, simply let her off, when he retired to consider submission, Musyoka is a free citizen. She did not have to plead to a ridiculous charge. We ask Your Honor that Honorable Jayne Kihara, whom I know as a mother and a senior leader, she had serving her 3rd term in Parliament, should not be before you for a misdemeanor. So we urge that when you retire to consider application that you letter off, and then when you had the maximum sentence for such an offense, a fine of 5,000 shillings. A real misdemeanor. So we urge that you order immediate release of Honorable Jayne Kihara, and we ask our colleagues in the political space to just adhere to the Constitution. That's all we are saying. I thank you all.
All right, thank you, sir. That's all we have.
Thank you, everyone. Once again, it must be afternoon already. Good afternoon.
Good afternoon.
Your Honor, we oppose the application for deferment and or rejection of these charges. And Your Honor, while we respect our colleagues on the other side, and we must commend them for a very good arguments today, especially my learned colleague, Mr. Njero, who I think must have preempted my arguments under Section 8. We've done this with him several times, I could see what he was doing. But Your Honor, I understand the application for rejection and or deferment of these charges to be founded either on Section 89, 4 or 5 by Mr. Ndegwa, or Section 134 by Mr. Your name is difficult. What? 89, 4 or 5, I think we could easily drop 89, 4, which deals with the drafting of charge. But 89, 5 about rejection of charges, or 134 as to, the propriety and contents of a charge sheet. And I thank Mr. Watuta for bringing 134 up, because Learned Senior Counsel has referred to a case before your brother, in which a charge was rejected on the basis of Section 89.5 on the same arguments, but which case from the onset you could say you're not bound by because it's a court of concurrent jurisdiction, it's not a superior court decision, and 2, a decision which may have been issued in error, and I will tell the court. The arguments, other than being based on Sections 89 and Section 134 of the Criminal Procedure Code, also is founded on a conflation of the criminal law vis-a-vis constitutional law of Kenya, and which needs some unpacking, a little bit of unpacking. And I'll say again that Mr. Ndegwa has done so well in his arguments on the constitutional perspective, which then I started. But Your Honor, for all of us, any court can only do as much as they are provided to do in terms of jurisdiction. Without jurisdiction, a court downs its tools, in which case you will down your blue pen if you are asked to do something outside your jurisdiction. As correctly noted by Mr. Ndegwa, the jurisdiction of the Magistrates Court to hear and determine criminal cases is provided for under Section 8, the jurisdiction of this court to hear and determine questions of alleged violation of the Constitution or of Bill of Rights is provided for under Section 8. Interestingly, I was listening so keenly, my learned colleague goes to Section 3, Section 4, then he gets to 8 and tells you Section 8.1. I want to read 8.1, which referred to, if you permit me. I can go to another as they look for it for me, because it seems it's not in my bundle. My colleague is assisting me with it. But in a sense, what it says from the reading as we wait for the actual text is that the magistracy have the power to interpret and apply the Constitution. Yes, correct. Thank you, sir. 8.1, claims relating to violation of human rights. That subject to Article 165(3)(b), which I'll come to shortly, of the Constitution, and pecuniary limitations set out in Section 7.1, a magistrate's court shall have jurisdiction to hear and determine applications. Hear and determine applications for redress of a denial, violation, or infringement of, or threat to right or fundamental freedom in the Bill of Rights. It does excellently well by bringing that out. But it leaves 8.2. Let's go to 8.2. The applications contemplated in subsection 1 shall only relate to the rights guaranteed in Article 25A and B of the Constitution. He deliberately ignored it because we've had this discussion. So that if there were allegations, if the arguments are based on alleged violations of rights of the Bill of Rights or any provision of the Constitution, if they went outside Article 25A and B, this court must drop its pen in respect of all the other provisions of the Constitution. And that will include Article 10, Article 19, Article 20, Article 21, and Article 27, and 33. But I'll address 33 again shortly. Because you do not have jurisdiction to hear allegations of discriminatory charges, if at all, if that's what they are saying, you would love to, but the Constitution says no. Another fundamental and a very beautiful argument that my learned colleague has made today was in his element, is that Section 94 was enacted on the first, became effective on 1st of August 1930. I must confess I didn't know, but I believe him. He's a good man. But he then gives the response and says there is Section 7 of Schedule 6. And it tells us what it says, that if there was a law existing before this Constitution, then read it with the necessary adoption, alteration, or amendments to bring it into conformity with this Constitution. So that answers the most difficult question he raised. Can we apply a law that was enacted in 1980 today? The answer is yes, and the reason is Section 7 of Schedule 6 of the Constitution. To that extent, Section 94 of the Penal Code, which was enacted in 1980, and which provides for the offense described in the charge sheet, then is still applicable today. And then there's another fundamental argument, again in its element, that one, you are at the same pedestal with the Parliament by dint of Article 10, that's correct. But that Parliament has been negligent, and that because of their negligence, don't be negligent, help them out. Interestingly, the suspect is a member of Parliament. It's very interesting. So that the suspect was negligent, leading to charges against her. But that is by the wayside. Now, Article 2, which Senior Counsel refers to, and I'll refer the court to Article 2, I think sub-Article 2 of Article 2, let me just look at it. And it says, no person may claim or exercise state authority except as authorized under this Constitution. You have no powers to make law. You have no powers to repeal laws. You have no powers to amend laws. That power belongs to Parliament. That Parliament which is inept and or negligent, in the words of the defense, is the only authority under this Constitution to make, amend, or repeal laws. And related to that, therefore, is that as long as that law has not been repealed, it remains part of the law of Kenya. And if that argument is correct, and I believe it is correct, then the argument about Article 50, sub-Article 2N, which is a very easy one to answer as we go on, that every accused person has a right not to be tried for an offense in respect of an act or omission, N, not to be convicted for an act or omission that at the time it was committed or omitted was not an offense in Kenya. This offense is an offense in Kenya since 1980. So until it is repealed, this court and the Office of the Director of Public Prosecutions has an obligation to enforce the law. There were very many fundamental issues of the Constitution, that's why I've taken some time on it. Then there is the question about Article 52B, which I'll marry what I've just said about 52N. You know, I have tried to persuade other benches of the judiciary, and I will try to persuade you today, that there was a deliberate intention to separate Article 49 and Article 50 of the Constitution. This is what I teach my law students at the Kenya School of Law in my guest lectures. That it was deliberate to separate the rights of unarrested persons vis-a-vis the rights of an accused person from a commonsensical look of the Constitution. So that when senior counsel started giving his opening speech, he says, no, I should not call her accused, let me call her suspect for now. And which I agree with, that we are dealing with a suspect, not an accused person. Then that, if I persuade you, takes you outside Article 50 of the Constitution, which is the rights of an accused person. So that, in other words, we are saying the rights under Article 50 are triggered upon the taking of plea. That argument may not be correct, but we are trying to persuade you that it is correct. And I hope you are right. Because it is this court that makes that determination. So then we have Article 52, Article 2B and 2N. We agree with our colleagues on the application of Article 25, that it cannot be limited by all means. But having spoken about there is the possibility of limitation of rights outside Article 25 by dint of Article 24 of the Constitution, that it permits the limitation of rights, except Article 25 rights, in the manner that would be done in an open and democratic society. You know, I'm not so hopeless. I believe ours remains an open and democratic society, at least from my end.
You are from our end, we hold the contrary position.
I hope you will enjoy my submissions like I did his while just sitting.
Let's give this interview.
So then, that deals with, I think, all the areas I captured. There is the suggestion that Section 3 and Section 4 tells you that you are bound by Article 10 of the Constitution, which is correct. All state and public officers under this Constitution are bound by Article 10 of the Constitution. However, the application, because counsel tries to make a distinction between interpretation and application, but whichever distinction he makes, the application of Article 10 still must be within the jurisdictional limits of this court. You cannot just say that because Article 10 binds me, if the High Court is wrong, I can correct the High Court because Article 10 obligates all of us to defend the Constitution. So Article 10 must still be interpreted in line with other provisions of the Constitution and statutory provisions. Then now we come back to the charge sheet, having done that constitutional analysis. You know, the reason I mentioned that your brother may have been in error in rejecting the charges under by dint of the provisions of Section 89.5 against Jayne. Of course, there will be a question whether or not the DPP appealed. That would be a different question. But this is why. The Honorable, allow me to read from my phone, Your Honor. I didn't know this would arrive, so I didn't bring copies, but I can supply these copies. In a decision by the High Court of Kenya in Milimani, Honorable Grace Ngenye Masharia, in the case of the Director of Public Prosecutions versus Kuldip, Kuldip, Kuldip Madan, and another. This was a miscellaneous criminal application number 809 of 2018, and it is reported in the Kenya Law Reports in 2019. It has very many beautiful provisions which I would have loved to read, but I'll just go to a few of them, all the way from paragraph 28, 29, 30, 31, 32, 33, and 34. But for purposes of brevity of time, allow me to read 33 and 34. This is what the learned lady says. And this got me interested because it clarifies the applicability of Section 89, including 89.5 of the Criminal Procedure Code. And this is what she says. It is my view that the formal charges properly drafted by a police officer or a public prosecutor, I hope my colleagues can get it online and just confirm that I'm reading the correct thing. It is my view that the formal charges properly drafted by a police officer or a public prosecutor, as is currently the procedure in our jurisdiction, should be governed by sections 134 to 137, and that's why I appreciated Mr. Watuta for bringing 134 up of the Criminal Procedure Code. Even if these provisions do not expressly provide for rejection of a charge, that omission does not fetter the court's inherent powers to control its processes from abuse. This is in view of the fact that courts of superior jurisdiction have settled the jurisprudence that would render a charge sheet effective, which argument can be advanced before a magistrate to persuade the court to reject a charge. Therefore, nothing stops an accused from advancing that a charge sheet is defective within the scope of the settled law, after which a court may find accordingly. A magistrate, if persuaded to reject a charge, should also address himself to whether the charge satisfies section 134 of the Criminal Procedure Code. That ought to apply to each charge in the instant application. But this is the most important 34. Having made my observation on the application of section 89 of the Criminal Procedure Code, I feel that courts should not continue to apply this piece of legislation to reject charges. The provision no longer speaks to the current procedure used of bringing charges to court. It no longer retains the meaning it had when Parliament legislated it. In other words, the arguments under 89 collapse because the decision of Honorable Grace Ngenye Macharia binds this court. So that all the arguments under 89 fall by the wayside. And then that leaves us with section 134 of the Criminal Procedure Code. Council has taken us through section 134, but let me just look at it one more time. Every charge or information, in this case charge, shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged.